Hi everyone, it's Nico here with a quick note before today's show. The interview you are about to hear with Rodney Smolla was recorded on May 20th and is about the events that occurred in Charlottesville, Virginia in 2017, which, if you recall, involved protests and counter-protests surrounding the removal of Confederate statues located prominently in that city. The events occurred throughout that summer of 2017 and culminated tragically with violence and death during the weekend of August 11th. Now, it's important I mention that this was recorded on May 20th because that is obviously prior to the protests that began last week surrounding policing and race in America. Of course, those two topics are incredibly relevant to the Charlottesville discussion, and had this been recorded after the recent protests began, Dean Smolla and I would have certainly connected the dots. Nevertheless, I hope to directly address the issues arising out of the recent protests, including the issues surrounding press freedoms, on an upcoming show. So please stay tuned for that. Now, on to this show.
Freedom of speech.
Fundamental rights.
Freedom of conscience.
Academic freedom.
Freedom of press.
And the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Hello, and welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. As always, I am your host, Nico Perino. It was 3 years ago this summer that a fierce dispute over the removal of Confederate monuments in Charlottesville, Virginia, captured the national attention. The events that summer led to racial animosity, heated debate over our nation's history and its founding principles, and threw one historic city into turmoil, ultimately culminating in death and tragedy during the weekend of August 11th, 2017. That August weekend, white nationalists descended upon Charlottesville for a third time in 4 months to protest the removal of statues of Confederate generals Robert E. Lee and Stonewall Jackson, which were located in Charlottesville parks. It was the white nationalists' right to protest. But how far does that right extend? And who, ultimately, is responsible for the violence that ensued? Our guest today is the author of a new book about the Summer of Hate in Charlottesville, which explores the events leading up to that deadly August weekend, the cultural currents flowing through America that led to its outcome, and how we should think about free speech protections for protests and, yes, hate speech. The book is titled Confessions of a Free Speech Lawyer, Charlottesville and the Politics of Hate, and the author is Rodney Smolla. Mr. Smolla is Dean and Professor of Law at the Delaware Law School of Widener University. He's also a First Amendment scholar and an experienced litigator who argued the seminal Ku Klux Klan cross-burning case Virginia v. Black before the United States Supreme Court, a case that is certainly relevant to what occurred in Charlottesville in 2017, and a case we discussed before on this show with his co-counsel David Baugh. Significantly, Dean Smolla was also appointed by then Virginia Governor Terry McAuliffe to advise the governor's task force on public safety and preparedness in response to civil unrest. The task force was formed in the wake of the Charlottesville events. Dean Smolla, welcome to the show.
It's good to be with you, Nico. Thank you for having me.
I'd like to jump right in because I have a lot to cover. Your book was fantastic, and I learned a lot about what happened in that summer of 2017 from your book.
Thank you.
By way of beginning, I've spoken with many First Amendment attorneys and advocates about the events in Charlottesville, some of whom appeared on this podcast. They include former ACLU folks like Ira Glasser, Nadine Strawson, Norman Siegel, Philippa Strum, Joel Gora. To a person, they assign most of the blame for what happened that weekend in Charlottesville to poor policing. However, you write in the book that you personally find it difficult to assign condemnation or blame against law enforcement in Charlottesville in any pointed sense. Why is that?
Yeah, I think so. Those folks that you mentioned are all my friends. I know a lot of them. They're terrific people. Nadine Strawson was nice enough to write a little blurb on my book. I guess once I dove into all this, I just thought it was too pat and too simple to just blame the police. The currents that were going through the country, the things that descended on Charlottesville that made it such a perfect storm, our deep divisions over race and identity, the American struggle to think through our free speech values, all of those things, it seemed to me, are important contributors. President Trump and some of the negative impulses in our country's culture that he has encouraged, I think, were part of it. So it just felt too pat and too easy to simply blame police. They did make mistakes, and there were lessons to be learned, but I think it's a lot deeper than that.
So the lessons to be learned moving forward, when we think about those, and when I think about past conflicts involving hate groups and counter protesters, you can't think about these sorts of events without thinking about the Skokie case in Skokie, Illinois in 1978, in which the ACLU was also involved. I am currently making a documentary about the life and career of Ira Glasser, who took over the ACLU as executive director in the fallout of the Skokie case in 1978. And in the process of making that documentary, I've reviewed archival footage from all the major networks. All of them, ABC, CBS, NBC, covered the Skokie case. And one of the things that you noticed in reviewing that archival footage, and Frank Collin and his band of neo-Nazis were regular protesters in the park, Marquette Park in Chicago. And so the police had a lot of experience working with them and the counter protesters. But one of the things you notice is just a tremendous police presence. And the police were not afraid to get in between the protesters, in this case, Frank Collin, and the counter protesters. And you didn't quite see that in Charlottesville, at least in the coverage that I've seen. And as you acknowledge in your book, you draw parallels to a neo-Nazi gathering in Madison Square Garden, I believe it was like 1939, in which you said New York City put out something like 7,000 police officers to prevent violence there.
Yeah, it was the largest assembly of New York police officers, I think, at any public event ever. I mean, they surrounded Madison Square Garden, where, it's probably shocking for us to think the garden was filled with American Nazis supporting the Third Reich and Hitler at that time period. And that was the response of Mayor LaGuardia to just descend on the garden with overwhelming force. So listen, don't get me wrong. I'm not saying that it wouldn't have been a lot better to have 3 times or 4 times as many police officers as there were in Charlottesville. Obviously, the Charlottesville Police Department couldn't have done that. They had everybody there, but you could have had National Guard, state police. You could have had a much larger presence, and we'd certainly have learned that lesson. So there was a similar supremacist rally following the Charlottesville tragedies in Boston, and the city of Boston pulled out the stops, both in terms of physical barriers and police presence, and avoided violence. And so, yes, that is probably the smart move. If you know that you're going to have warring groups descending in a tight, in tight proximity, that's probably the smart move going forward. So I guess what I was saying is, to me, the confrontations were much more revealing about our country, our views of free speech, our struggles with race, than just to say, "Oh, it was an error. The cops blew it."
And the cops, they're between a rock and a hard place. As you talk about the previous white nationalist rallies in Charlottesville, the police seem to have been more proactive in some of those earlier rallies, but they took criticism for that. Note that the police were essentially protecting the white supremacists from counter-protests in the sense that their backs were to the white nationalists and they were facing the counter-protesters.
One of the things I've suggested, obviously I'm not a law enforcement expert, but one of the things I've suggested is in the future, if the bad guys, if the racial supremacists, or the Klan guys are going to be running a gauntlet, and you've got to create a space that gets them to the park they're supposed to be at, or they have a parade planned, and they're going to be people screaming and jeering and yelling at them from the sidewalks. Then you should have your officers deployed so every other one is facing inside and outside. So half the police are facing the marchers and half the police are facing the counter protesters. That just sends the symbolic, signal. We're protecting each of you against each of you. We're keeping you apart, and we don't just have our backs facing the Nazis and our fronts and our weapons facing the counter protesters, because that creates the optic that the cops are there to protect the racists.
Yeah, that I haven't heard that before, that suggestion, but it seems very like a good idea.
It's a little, maybe it's silly in the mechanics, but it the deeper free speech question is that there was a time in our history in which if somebody was an agitator and causing unrest and crowds were getting restless, our First Amendment law said you can remove the agitator. And the famous case is Chaplinsky versus New Hampshire, where Walter Chaplinsky was this over-the-top Jehovah's Witness street preacher that was criticizing all sorts of other religious traditions and making people, fidgety and starting to look like they're going to be trouble. And a police officer, seemingly doing the right thing, tried to get him to chill, just kind of move on down. Why don't you just, come back another day? Walter Chaplinsky didn't want to do it. He cussed at the officer and he got arrested. And he took his case to the Supreme Court of the United States. And the Supreme Court sided with the police and against Chaplinsky. So that's a case that's one of the most famous free speech cases in American history. I think it's now largely overruled. But if you think about it, what went down there is we allowed the angry crowd to silence the speaker, who himself was not violating any law. And our law has since flipped around. It's flipped to the opposite side. We now respect this notion called the Hecklers Veto. We don't want the angry crowd to be able to shout down the unpopular speaker. And I think that's the right rule. But that rule, as you say, really makes it tough on the police because they're now in the uncomfortable, unseemly position of looking like they're siding with the speaker that may not only be unpopular, but may be pretty much by most people universally condemned, like the white supremacists.
And they have the job to keep them separate, but they also have the job to not keep them too separated, right? So Fire co-founder Harvey Silverglate, criminal defense attorney up in Boston, after that Boston rally, criticized the efforts of the police, and I think he cited or quoted, who was it, Tacitus or someone. He said, "They make a desert and call it peace." The police in Boston separated the protesters so much that there was no ability for either side to engage it with each other. Right. So you got to be careful about that too.
Yeah, you have to be careful about that. And if we really want to think this through, theoretically, you want each side to be able to send their message to the other. And so that's the idea, that they have to be separate, but they have to be able to engage. Now, if we're going to be realists, the odds that the marketplace of ideas is really going to matter a hoot in that situation is really low.
Yeah.
Because I just can't see the people from Antifa converting the Klan, and I can't see the Klan converting the people from Antifa. There's no real genuine interest in doing anything other than screaming at each other. But we do have this notion that you should be able to hear the other side's jeering and screaming. So, I agree with the comment that they have to be not so separate that the whole idea of the protest and the counter-protest is lost. But I also think realistically, the notion that there's going to be any serious discussion is ridiculous.
So you write that if I'm reticent in assigning any deep moral culpability to Charlottesville and UVA authorities, I have no reticence in assigning full responsibility for all the death and destruction in Charlottesville to Richard Spencer, Jason Kessler, and their many radical supremacist disciples. These are the organizers, of course, of the Charlottesville rally. You also note that their message was fraught with death. It's a paraphrase. But is this analysis unique to the facts of the Charlottesville case and the specific actions of its organizers? Or in your opinion, to the extent there is ever a hateful message part of a protest or rally that turns violent, do the hate mongers maintain the bulk of the moral culpability? I'm thinking here.
That's a great question. I think it's some of both. So, right now there is ongoing litigation in Charlottesville in a civil case brought by a number of people who were injured in the violence against the planners of the Unite the Right rally, a number of the people that you've mentioned by name and others. And the hypothesis of that civil suit, which is going forward right now in federal court in Charlottesville, is that this was a conspiracy to trigger violence, that these folks knew there would be violent confrontations and they wanted that, and that was part of their point. That was part of their tactic. And we'll see if the evidence supports the allegations, but I wouldn't be surprised if the evidence does support the allegation. So, and at least the record that I had, what I was able to put together in researching the book, lends plausibility to the notion that is what they had in mind. And so, if proven, there is moral culpability there. Now you ask me another question, which is, even if I am totally respectful of free speech, is there an automatic condemnation in which more moral culpability resides with the people who have messages of hatred and genocide and racial superiority? And my answer to that is yes. And so, although our free speech values require government to remain neutral, they don't require me, Rod Smolla, to be neutral. And I can say, as between the counter protesters who are their message is inclusion and human dignity, and the supremacists who have a message that comes from Nazi ideology and racism and anti-Semitism, I have no problem saying there are good guys and bad guys, and when they come together and somebody gets hurt, there's an automatic residue of blame that, in my view, I'm willing to assign to the bad guys.
So to draw more parallels with Skokie, because I'm making this documentary and reviewing so much footage related to the case, Mayor Kahan, or Kahani, I forget how you pronounce his last name, Rabbi Kahani of the Jewish Defense League, said in one of the clips that we use in the documentary, the Nazis will not march in Skokie. Should the Nazis appear, we will break their heads. There will be violence in the streets. And then you have Frank Collin on an ABC newscast saying, I can promise this. They come hell or high water, Supreme Court or no Supreme Court, arrest or no arrest, violence or no violence, Rabbi Kahani or no Rabbi Kahani, we are going to Skokie, by God, this year. We don't care how much violence they're going to bring on their heads. We'll give it back to them 3 times as much. And then I'm interviewing David Goldberger, who was the lead attorney in that case. And I asked him, of course, the march in Skokie never happened. I said, had the march had happened, do you think there would have been violence? And he said, yes, I think there would have been bloodshed. So you have here both sides, the protesters and the counter-protesters, signaling violence. Had the march had happened like it did in Charlottesville, how would we assign blame there? And it's really hard to think about a situation in which you don't depend almost wholly on the police, or you see these quotes or hear these quotes, and you forestall the rally altogether. You say the facts of this case, what they've been talking about, this is a conspiracy to commit violence. We cannot let this move forward. So I'm having a hard time, because we think of Skokie as the seminal free speech case that is so indicative of our First Amendment values here in the United States. But at the same time, you have some of the leaders of the protesters and counter-protesters saying some of the same things that you cite in your book as the protesters and counter-protesters saying leading up to the rallies in Charlottesville as well. That could make them responsible for the conspiracy charges, or could find them guilty of the conspiracy charges.
So I don't. I'm a litigator, and like a lot of litigators, I forget what I've written 3 days after the case is over.
You and me both. I mean, I'm not even a litigator, and I forget what I wrote yesterday.
And so I was just listening to some passages which you quoted me in my book, and I said, "Geez, did I write that? That's not so bad. I like the way I said that." I've forgotten I'd said it, but look, my memory is that in Charlottesville there were not was counter-protesters who were planning violence. There were 2 different groups. There was a group of people from within Virginia and outside of Virginia who took the sort of classic ignore them. Let's have our own counter rallies. Let's not give them the dignity of shouting them down. Let's ignoring them is the best thing we can do. And there were clergy within Charlottesville and government leaders and UVA officials that took that view. And then there was the confrontation view. And the confrontation view probably, in terms of numbers and intensity, kind of won out. I think there were more people, who were of the view that the supremacists have to be confronted. So people in the Black Lives Matter leadership and Antifa and other groups like that, and many of the Charlottesville clergy took the side of confrontation, but it wasn't phrased and planned as violent confrontation. It was not, we're going to bust their heads sort of thing, which I hear the rabbi saying in Skokie. And so there may be a little difference there. Now, if you ask me, were there people who were on the counter-protest side in Charlottesville who came wanting to punch somebody in the nose, wanting to nail somebody with a brick or a sign or something? Probably. There probably were, but I don't think that was the driving ethos there.
So one of my other concerns about the civil cases going through in the wake of Charlottesville is last year the Fifth Circuit Court of Appeals held that Black Lives Matter activist DeRay McKesson would potentially be held liable for the actions of a protester who allegedly threw a rock at a police officer during a protest in Baton Rouge that McKesson helped organize.
Right.
Now, this had many First Amendment activists, including myself, very concerned because it seemed to run contrary to that 1982 case, NAACP v. Claiborne Hardware, which you discuss in your book extensively.
Right.
And that case held that civil liability may not be imposed merely because an individual belonged to a group, some members of which committed acts of violence. So how do you think about that case in light of what's happening in Charlottesville, and how do you see them as distinguishable?
Yes, I read the Fifth Circuit case, and I did think it was probably wrong. I don't think the proof was there. But and it seemed to be almost a kind of strict liability. You planned the rally and the violence ensued, and that struck me as inconsistent with Claiborne and a whole host of First Amendment cases that we could run through. In the Charlottesville case, the accusations are far more pointed and detailed, that there was behind the scenes logistical planning, anticipating violence, or using code for conspiring to engage in violence or provoke it. And so that, I think, is the distinction. As is often the case in First Amendment litigation, evidence matters and facts matter. There's not a single area of First Amendment law where that's not true. You have to prove actual malice in a defamation case. You got to prove, that speech was directed to the incitement of imminent lawless action and likely to produce it in an incitement case. You got to prove a true threat in like the Virginia v. Black case that I did. So facts matter. I'm saying that I read Judge Moon's opinion. He's the federal district judge in Charlottesville that allowed the suit to move forward. He assembled an impressive compendium of factual material in that opinion that I think was enough to cross the line. And so I think that's the nuance I draw between the two situations.
Yeah, that these First Amendment cases really depend on the facts and an intense analysis of the facts, and kind of taking that fact-based analysis thread and looking a little bit further back. As many of our listeners know, leading up to the Unite the Right rally, the Charlottesville City Administration sought to move the rally away from its originally scheduled location near the Robert E. Lee statue to a different, sort of more remote location. Now, the Virginia ACLU and the Rutherford Institute intervened and represented the rally organizers, arguing that to move the rally would violate the organizers' First Amendment rights. And as we were just talking about, when a judge is analyzing these sorts of efforts, they really take a fact-based analysis to see whether there's actually sort of a clear danger that violence is imminent. The ACLU, Rutherford Institute, the rally organizers prevailed, and the rally location was not moved. Now, you were also asked to represent the organizers, but declined. Now, if I'm recalling the book correctly, I don't know that you actually, or you may have, and I'm just not remembering it correctly, said what you thought of the judge's opinion in that case. Do you think that the city had the right to move the rally at the time? And if so, how does the post hoc thinking about it go?
Right. So Judge Conrad's decision in that case was largely grounded in evidence that there were people making the decision in Charlottesville who were doing it out of hostility to the racial supremacists' message. So it was a decision tainted with a censorship motive. And I don't remember all the details, but things like minutes from a city council meeting or an email message or something like that. And so because it didn't appear to be a neutral decision grounded in public safety concerns, but a decision basically to kick the supremacists out to the state park on the outskirts of Charlottesville, while allowing the counter protesters to continue in their venues in the downtown area of Charlottesville near UVA, it seemed like it was tainted with viewpoint discrimination. And that was the basis of the judge's ruling, and I think it was sound. I think the judge was right. I'm sure he feels remorse in a way because of the violence that ensued. I doubt that he I'm guessing that he feels he made the right decision on the First Amendment merits, as I think he did. But you can't help but feel, horrible when violence then ensues. If there hadn't been that taint, and sorry for my rambling answer.
No, this is important. Yeah.
If there hadn't been evidence of viewpoint discrimination, and instead it appeared that the decision makers just thought that the downtown area was just too compressed. I've spent a lot of time in Charlottesville. These squares are not large. The streets are narrow. It's a town that's difficult to get around in, even in normal times. There's always traffic snarls and things like that. And you suddenly think you might have 10,000 people there, and they're opposed to each other. And the city said, listen, you can all come, but let's go where there's more grass and we can put up bigger barriers and so on. Then that would have been a tempting solution. Now there's one First Amendment problem with that solution, and that is that the marchers want to be in front of the statutes. That's their whole point. They want to save the statutes. Maybe you could have had some sort of deal where, 200 each around the statutes, and the other 5,000 have to go out to the park. So it's not inconceivable that something like that could have been pulled off that would have been permissible under the First Amendment. But I think that given the cards that Judge Conrad had in front of him, and you have to remember that hearing took place just a few days before the scheduled rally. I think he made the right decision.
Now, we're talking about all the controversial aspects of Charlottesville today. Much was made of the presence of weapons in Charlottesville that weekend. You argue in the book that the city had and has the legal authority to restrict the presence of weapons in sensitive locations, including at protests and rallies, consistent with the Supreme Court precedent, which said that the government can restrict the bearing of weapons in sensitive locations. But historically, sometimes the presence of weapons at protests served symbolic, expressive purposes. And were used as defensive deterrents. I'm thinking here about the Deacons for Defense and Justice defending civil rights marchers in the Deep South in the 60s, or the Black Panthers. So how do you think about those competing concerns?
Yeah. So this was one of the big things that the task force that Governor Terry McAuliffe appointed later struggled with. And I took a pretty strong position in advising that task force. And I think a lot of people probably disagree with me. You might, but I said that in my view, the Second Amendment does permit the government to de-weaponize large rallies. I mean, none of us expect to be able to carry a gun into an NFL football game or Madison Square Garden or many concerts and things like that. We're used to having to check weapons at the door for certain sorts of things. And I said, even in a public forum in which by tradition you have whatever Second Amendment rights you have to have your weapon on you and carry weapons, that when the forum, when the park or the streets are turned into a rally, it becomes like going into a stadium. And for public safety reasons, you can make everybody disarm. Now, we have no idea whether what I just said is right or wrong under the Second Amendment. The Supreme Court has not taken many cases since its original Heller decision, but it could well be right. And I said I thought it made perfect sense as a matter of Second Amendment doctrine to say that. Now there's a nuance there are a couple nuances that your question raises. One, by the way, it actually was part of the oral argument that I had when I argued in the U.S. Supreme Court, Virginia versus Black. It was a colloquy, if that can ever really be true, between me and Justice Scalia. By that I mean he had his point of view, and he was coming down hard on
Well,
me.
he got you, is what he said, right?
No, Justice Thomas was the one who said he got me.
Oh, is that Thomas? I'm watching the documentary about Justice Thomas right now. It's pretty good.
Justice Thomas, that was the case in which he spoke for the first time in 7 years, and surprised us all by what he said, and dramatically, I think, impacted the atmosphere in the courtroom. And he got Justice Scalia to go with him. They were the only two justices that went completely against me in that case, where I represented the Klan and represented, the rights of cross burners. But the particular dialogue involved the use of a weapon that was unloaded. That was Justice Scalia's hypothetical. And could that be a threat? And I said, yeah, it could be a threat because the person threatened doesn't know that it's unloaded. And I said, that's different from a cross. You know that the cross itself is not going to hurt you. It may mean in a particular case we're coming after you, but it's different in kind than a gun loaded or unloaded. But to go back to the more interesting question, I do believe you might have a First Amendment right to bring an unloaded weapon to a rally if the rally's about weapons. I mean, I think you might want to be able to have an unloaded gun because you want to make a point about the Second Amendment, something like that. But I'm of the view that Second Amendment doctrine is sufficiently flexible. And I know this is a First Amendment show, but there was only one number off.
No, there's intersections here. I mean, we're talking about symbolic speech.
Doctrine is sufficiently flexible to say when we have large rallies and maybe you'd add, and we anticipate the possibility of violence, we're not going to allow loaded weapons. Now you can get all kinds of cute problems, like what's a weapon, and
you also have state constitutions to contend with. Like I know Pennsylvania's.
Well, and by the way, the advice that I gave would run into big problems in Virginia because Virginia does have a panoply of laws that give a lot of gun rights, and also that largely disable local governments from making some of these measures. So my testimony was based on the U.S. Constitution. There were other issues that Virginia had to face involving its panoply of laws. But again, I could be right, I could be wrong, obviously. But I'm of the view that there's not a Second Amendment right to attend large rallies that have been permitted, even if they're in public parks and public plazas, with a weapon.
Yeah, in thinking about this and thinking about how things might have gone differently in Charlottesville if weapons were prohibited, I don't know that things would have been all that much different because as you recount in your book, the events that occurred that weekend occurred all throughout the city and not just within the permitted rally location.
Sure.
I suspect that not much of what occurred that weekend actually occurred within the permitted rally location. So even if you prohibited the weapons within the rally location, you would still have weapons elsewhere, including at the intersection where Heather Heyer was murdered, albeit she was murdered using a car. So
the car was the weapon. Yeah. So I don't mean to say that banning weapons would have necessarily changed much in Charlottesville. But what Virginia officials wanted to know, and a lot of people around the country wanted to know, is, but can we ban weapons, at least in those situations where we think it could be safer if we don't allow them? And my view is yes.
So a good portion of your book provides the background to the competing theories of the First Amendment that have existed throughout American history. There's the order and morality theory that predominated through most of America's history, and then there's the marketplace theory, which you've alluded to already, which began its ascendancy, early in the 20th century, but really legally began its ascendancy in the 1960s. Now, you argue in your book that the Unite the Right rally in Charlottesville could have never happened if the order and morality theory of free speech continued to reign. Why is that?
Yeah, so these are my own kind of nicknames. There may be other people that have used them before. When I teach this to law students or talk about it with anybody, think it's a nice way to organize our thinking about free speech law and to really kind of talk about how the American tradition is unique in the world, because most of the world still follows the order and morality theory, and so the proof that if you adopted the order and morality theory, which, by the way, the phrase comes from the Chaplinsky case, which I talked about a little bit earlier in our interview here. If you want the proof that that theory would allow you to completely ban rallies like the Charlottesville Unite the Right rally, the case is Beauharnais versus Illinois, which is from my hometown, Chicago.
I'm from Chicago as well. Well, suburb Elmhurst.
And so I thought you might be, and you know, I make a little bit. By the way, this is a little bit of a segue, and maybe I don't mean to trivialize things, but you know, in the Blues Brothers, one of the great Chicago movies of all time, there's the scene where the Blues Brothers, you know, go after the Illinois Nazis.
What's going on?
Those bums won their court case, so they're marching today.
What bums?
The fucking Nazi party.
Illinois Nazis. I hate Illinois Nazis.
John Belushi says, "I hate Illinois Nazis," and they go after them, and the Nazis come off in the Blues Brothers as silly, impotent, almost a joke. A little bit like David Duke comes off in Spike Lee's movie The Black Klansman as kind of ridiculous. And one just as a cultural thing, I note how they were marginalized and thought of as ridiculous at that time, and how they're not marginalized now. I mean, their numbers may be marginal, but there's a sense of the cultural presence of the supremacists like Richard Spencer and so on that's come a long way. They've made progress since those guys.
I think they've kind of waned since Charlottesville, but yeah.
Yeah, I here's the diversion. The case I was talking about is Beauharnais versus Illinois, which is a 1952 decision, and it followed the Chaplinsky theory. And the people in Beauharnais were part of a group called the White Circle League. They were racists in Chicago, and they were passing out leaflets that were viciously racist because they were opposed to what appeared to them to be the incipient movement of the Democratic Party toward civil rights. They thought that Harry Truman and others were moving towards respecting civil rights, and they wanted to stop that. And they passed out these vicious, racist leaflets throughout Chicago. And the case went all the way to the Supreme Court of the United States. And Justice Felix Frankfurter wrote an opinion that alluded to Hitler and the Third Reich and said Illinois does not have to allow this kind of speech. And it eats at the fabric of society. It tends to cause racial strife. We see where it led to in Europe, and we know there have been racial tensions in Illinois, and you can just ban this speech, make it a crime to say these things. So that, to me, that case was the high point of the order and morality theory in 1952. And
it also established the group defamation theory, which I know is
exactly, group defamation is a classic kind of version of the order and morality theory, and it expresses the view that it's wrong to say wicked things about Jews or blacks, and of course it is wrong. It's morally wrong. It's reprehensible, and so that was our law as late as 1952. And then, as you've already mentioned, everything changed in the 60s, and we began to see this parade of U.S. Supreme Court opinions stretching out until, this right now that reject that view. And so I think had that not happened, had we not migrated away from the order and morality theory, the city could have just said, "Hey, guess what, guys? We don't allow this kind of talk in Charlottesville. You're banned. You have no right to come into our streets and make these points," which is the law today in Europe. I mean, it's the law in most places in the world.
At the end of your book, you kind of explain why you reject the order and morality theory of the First Amendment. And I'm making this documentary, so a lot of what you say in your book has me reflecting on the documentary. And there's this scene in the documentary on the Phil Donahue show, a very popular show through the latter half of the 20th century. And there was an episode that Phil Donahue did, I believe in the late 80s or early 90s, about whether the government can ban the Ku Klux Klan from appearing on cable television. And on that segment appeared a FBI informant who embedded himself within the KKK. Also appeared was this Mr. Stoner gentleman who was a leader of a Ku Klux Klan group. Also appearing was Hosea Williams, who you discuss in your book, a civil rights leader, a deputy of Martin Luther King, and the man who led the march through Forsyth County that resulted in people throwing rocks at civil rights leaders, and one of the big Hecklers Veto case, if not the biggest Hecklers Veto case in American history. But also appearing was Ira Glasser. Now, Ira was Ira Glasser, the former executive director of the ACLU, and Ira just suspected that when he appeared on that show that Hosea Williams, this civil rights icon, would be against him, that Hosea Williams would take the side that the government can ban the Ku Klux Klan. I mean, he would have every justification for doing so. He had rocks thrown at him by the Ku Klux Klan when he tried to march in Georgia, in Forsyth County. But he took Ira's side in that and surprised Ira. But there was a very revealing question from a member of the audience during that segment. The audience member, I'm going to quote the audience member. She said, "Everybody's talking about the First Amendment, and we have a preamble to our Constitution that is supposed to promote domestic tranquility. It seems so clear of what would be right and what would be wrong. This is promoting hatred. This is not promoting domestic tranquility." And then the problem with the order and morality theory of the First Amendment made itself crystal clear when the Ku Klux Klan leader, Mr. Stoner, intervened in her question and said, "Excuse me, but I'm the leading advocate of peace and tranquility in the country. I've declared a program where we'll have only a white Christian America, and then we'll have peace and tranquility and no more lawlessness."
Yeah.
Peace and tranquility is in the eyes of the beholder. And, so while your peace and tranquility theory might eradicate the hate groups in Charlottesville, Virginia, or Chicago, Illinois, what are they going to do in Forsyth County or in Montgomery, Alabama in the 50s, or in Selma?
Right.
And then you didn't have this in your book. I was waiting for you to quote it, but I know books go to print long before they're actually released. Susan Bro, the mother of Heather Heyer, during the October Open Future Festival hosted by The Economist, was asked point blank by her interviewer, "Do you believe that those protesters who were there in Charlottesville that day had the right, or should again have the right, to express their views?" And she responded, "I do." I mean, again, someone who had every right to say no, because her daughter was murdered by one of them. She then goes on to give a very moving argument for why free speech must be defended and the order and morality theory must be rejected. She said, "My big concern with losing free speech is who makes the decision what speech is allowable and what speech is not. And once you set it up so that there's always one group deciding, that group can change at any given moment." So that's the concern with order and morality.
Yeah, and I think that's exactly where I came out. I am suspicious that the marketplace works very often. We know the opposite is true. We know that often the hateful messages seem to prevail. I mean, they obviously did with the hysteria that overtook Germany. They do all the time. And so the idea that somehow truth will emerge because of this back and forth of ideas, it sounds nice, but I'm skeptical. I think the argument is the one you've made, the legitimacy argument. That and here's where I think I often struggle with my own children. I have a daughter who was an activist at Yale. Her name is Corey, and she was in the midst of a lot of these debates at Yale. That I went to Yale too. I went to Yale as a football player. She went as someone who actually was smart enough to get in on her own. But her view. It's a lot like the woman who asked the question on the Phil Donahue show. Her view is, well, come on. There's a difference between the free speech rights of Martin Luther King and the civil rights movement, because they were on the side of right. They were on the side of righteousness. They were on the side of equality. They were on the side of dignity. we can make distinctions between good ideas and bad ideas, between good people and bad people, and the racists are bad, and we all know it. And it's wrong to say the First Amendment doesn't allow society to make those judgments. I think that's a powerful argument, and it's one in the end I don't embrace because of the legitimacy problem, the who's going to decide problem. But I don't like to trivialize it because I think it has a lot of resonance and a lot of power, and it has a pull on us, and that's why I know we're coming to an end of the show pretty quickly. But one of the things I do point out is that even though the marketplace idea has become the dominant view in American law, the order of morality theory is still the theory we follow in large pockets of our society. So we use the order of morality theory in the workplace. If you're a racist in the workplace, you can lose your job, and in fact, your employer can be in trouble if they don't fire you. We use the order of morality theory to a large degree in universities. Even though people have a right to scream at each other on the college green, they have to treat each other with a reasonable amount of dignity, in other settings like classrooms and athletic teams and things like that. As lawyers, we use the order of morality theory. I can't mouth off to a judge and not expect to be thrown in court, thrown in jail for contempt of court. So both theories are part of our society, but we let the marketplace reign in the open spaces.
Yeah, I think within FIRE, and I think with a lot of First Amendment advocates, we just don't see the marketplace justification as compelling as it maybe was in the 20th century. Here at FIRE, and our president, Greg Lukianoff, has this other theory called the lab in the looking glass. He says, the marketplace theory, truth might win out, but it's usually in the long term, and sometimes it loses out in the short term. But the more important value is that allowing for free speech allows us to see the world as it is, which is important, not just when people believe hateful things, but especially when they believe hateful things. I mean, censoring someone is like breaking a thermometer. You might not know what the temperature is anymore, but the temperature still remains, and it still creates public policy problems that must be addressed in a more significant way than just finding them or throwing them in jail. I think the most compelling thing that you cite in your book, and the strongest challenge to the marketplace theory, is that, are we really going to change our minds about the value of inclusion in our society? You quote a UVA professor who talks about, and I hope not. But there's more to it, whether the truth is going to win out or lose. I mean, there's also all the John Stuart Mill arguments that, if you foreclose an argument, you begin to hold that truth as a dead dogma, not a living belief, that you just don't know how to defend it anymore. I don't really know how to, I don't have to go out and defend gravity every day. I don't have to go out and defend the fact that the earth is round every day. So I probably am not going to make the most compelling argument to a flat earther. So
another thing, I guess it's a cousin of what you've just said, is the idea that really you see it first in American legal writing with Justice Brandeis's opinion in Whitney versus California. I nickname it the Kudzu Theory, or maybe the plant's called Kudzu. One of our daughters had just graduated from college, just did her whole English major report on that plant. But kudzu is this plant, you see it particularly in the South, where it just takes over an area. And if you hack at it and cut it back, in your yard, it comes back 10 times stronger. But it's the idea that you actually make evil speech stronger by censoring it, because you drive it underground, you make it a martyr, people rally to it, you generate more suspicion against government, and you haven't made anything any better. You've made things more dangerous. And that was one of Brandeis's central theories in that case. And I do find that to be absolutely convincing. I do think if you just ban the speech of the racists, you're going to have more racists.
So I realize we're coming up on 45 minutes here. Do you have time for 2 more quick questions?
Sure, absolutely.
So
I'm in quarantine. I got time. I got all the time in the world.
I know it's like Groundhog Day over here. This is like the most exciting part of my day. It would be regardless of whether we were in quarantine, but you know what I mean. So in 2018, we at FIRE surveyed 2,400 undergraduate students about free speech and the events in Charlottesville. we found that 67% of students remember reading or hearing news reports about the protests. What's more, 35% of students said the event changed how they think about free speech and expression on campus. What do you see as the short-term and long-term implications for the First Amendment of the events that occurred in Charlottesville?
Well, I guess what I'd say is that 35% should buy my book.
Well, 15% of them actually, because we allowed for open-ended questions, and then we did sort of like an aggregate analysis of those. We found that 15% of that 35% actually made their beliefs in free speech stronger as a result. But the majority I think, were more apprehensive.
I mean, I do think that cultural moments like this impact our collective thinking, and I have not been in that group that I think of FIRE as part of the group that says college students today don't understand free speech. You notice in my book I don't say that. I say, well, they understand it. They just understand it differently. They don't come from the marketplace orientation that I do. That doesn't mean they're not sensitive. But I do think that event was probably a significant formative event for a lot of that generation, the college-age generation in the United States. It looked to a lot of folks that watched that as if this is where the First Amendment gets you, and it's not a good place for us to be. So I think that's a realistic assessment of the impact it had on a lot of people. And I try in my book to not write that off as naive or to not trivialize it, but to deeply engage it and still try to explain why. At the end of the day, I think you have to allow that speech, as hateful as it is, to have its venting.
So the last question here, defamation. Now, a portion of your book discusses representation of plaintiffs suing Rolling Stone for a story they published and subsequently retracted about an alleged gang rape of a woman at the University of Virginia fraternity. I mean, University of Virginia was at the center of a lot of controversies there in the past couple of years, especially around 2016, 2017. The story was shoddily sourced, and it severely harmed the lives of some of those within the fraternity and the administration at the University of Virginia. And if ever there was a claim for defamation, this was probably it. You also represented plaintiffs in a lawsuit against a book publisher that published a book that taught people how to be a hitman or assassin. And in this case, there was someone who killed, I think it was, 2 or 3 people?
Right, 3 people.
3 people, and used this book kind of as a tutorial.
Right.
Now, representing plaintiffs in defamation cases or in cases against publishers is often looked down upon by members of the First Amendment bar. I think some publishers and trade groups even require their lawyers or members to commit to not representing plaintiffs in these kinds of lawsuits. So what are your thoughts generally about this sort of thinking? And have you experienced criticism from your colleagues for doing that? And I think about Nat Hentoff, because you talk about Nat Hentoff, the famous civil libertarian in your book, who commended you for your representation.
Yeah, great civil libertarian and great jazz critic, one of the great jazz writers.
But he also was a critic of defamation law generally.
Yeah, he was. So look, I have taken heat from a lot of my friends in the First Amendment bar for being a plaintiff's lawyer. I have a really cordial friendship with Floyd Abrams, who's maybe the most famous First Amendment lawyer ever in American history. And he and I have been friends for a long time, and we've been on the same side of cases. We've written briefs together, but we've been adversaries. He's always a defense lawyer in defamation cases, and I've been against him in defamation cases. And I could go down the line of very well-known First Amendment lawyers with whom I have been allied in many, many cases, but against in cases where I take plaintiffs' sides of cases.
And you're not alone. There's also, I interviewed on the show Martin Garbus, who also represents plaintiffs. And no, I'm not alone. And when I took the Hitman case, that's the Rice versus Paladin case, a person who was also a friend, Adam Liptak, who now covers the U.S. Supreme Court for the New York Times, but in an earlier time in his career was an actual lawyer for the New York Times before he became a journalist. He called me a traitor to the First Amendment. In print?
And yeah, in print. And I think, I could take it. It's no big deal. But so I'm used to that. Here's my simple answer. I believe the rules are right and I play by the rules. So In defamation cases, the actual malice standard is an appropriate way to protect free speech, but still creates some opportunity for a person who is defamed to protect their reputation if they can meet that high standard.
So you wouldn't
When I
ascribe
take a
to
defamation case involving a public figure, I have no illusions. I'm not trying to get the court to abandon the actual malice standard. I'm trying to get the court to play it straight. And if I have the proof of recklessness, I think we did, for example, in the Rolling Stone case. I think it was I think that's why the case settled. If we have proof of it, we win. If we don't, we lose. And I could pretty much go down the line and in all these cases that where I've been on the plaintiff's side and say I'm not attacking the rule, but as applied to these facts. This sort of loops back to what you and I were talking about earlier in the current litigation going on in Charlottesville. If the facts are there to show that the standard has been met, whatever it may be in a particular First Amendment case, then there's nothing wrong. In fact, it's appropriate because free speech is always in tension with other important values, with equality, with the protection of reputation, with protection of consumers. It's not an absolute. And if you can meet the standard and someone has violated and crossed the line, I'm 100% comfortable with being a crusader for the person that was injured.
One of the challenges that we have at FIRE in talking about the law is that there is what the law is, and there is what you want the law to be.
Right.
And so you wouldn't then, based on kind of what you said, reading through the lines, you wouldn't then subscribe to Justice Clarence Thomas's idea that we should re-examine New York Times versus Sullivan and the actual malice standard. You actually think that the standards that are in place right now are the best at balancing the competing interests in these cases.
And so when Justice Thomas wrote that, he was heavily criticized, and I wrote an op-ed right after Justice Thomas's opinion, and I said, look, I don't think we should abandon New York Times v. Sullivan. He makes some valid points, but a lot of the points he makes, one of his main points is that the case is ahistorical. It can't be squared with what the framers of the First Amendment had in mind, or those who adopted the 14th Amendment had in mind. And of course, he's right. But you could say that about 99% of our free speech law. Almost all of it's ahistorical. I'm sure the framers wouldn't have expected a lot of the free speech doctrines we have. But I did. But let me make another point real quickly before we go, and that is, I do think that the way the landmark defamation cases were decided, and I mean the cases from New York Times v. Sullivan through the Gertz case, which is the case that said we also use the actual malice standard for public figures. I do think that in the decades since those landmark decisions, some courts have drifted in their application of those cases and are providing more free speech protection than those cases contemplated. And some of I think more people are classified as public figures than should be. I think that often things are treated as opinion, maybe too promiscuously. They're really facts, but courts are maybe too quick to call them opinion. And the proof that you have to show actual malice is sometimes, I think, more demanding than those cases contemplated. These are quarrels on the edges. This is inside baseball type quarrel. So I think Justice Thomas may have some. I kind of, in a way, would like the U.S. Supreme Court to take another big defamation case. It's been a long time since they have, and some of these issues are festering, and they need some resolution. And Justice Alito made the point too recently when the Supreme Court denied review in a case called Mann, which involved the fact versus opinion distinction and who gets to decide that, juries or judges. I'm guessing there will be a big defamation case that the Supreme Court takes sometime in the next year or two or three. And it may kind of go back and I don't think it'll change any of the substantive doctrines, but I think it may fine-tune them a bit and recalibrate them a bit. Maybe in one direction, maybe the other. I don't know. But I think there might be some interest in doing that.
I'm actually surprised they didn't take that Mann case. I mean, there was a lot of, it seemed like public appetite.
An army of amici. Yeah, I kind of thought they might, but they didn't. But I hope they take one soon, and I hope I get to argue it.
Is the Virginia v. Black case your only case in front of the court?
Yeah, it is. And of the 20 or so cases that I've been involved in which there were serious cert petitions, it's not the one I would have thought the Supreme Court would take, but it is the one that they.
Yeah, because they had the RAV case, which seemed pretty similar to me. It was distinguishable in certain significant ways as well, but it wasn't too far before the
right. 10 years, only 10 years before.
Yeah.
Right.
But the court sometimes takes free speech cases back to back, like whether flag burning. I think there was a couple of flag burning cases there in short order.
Right.
Well, I could keep talking to you all day. There's plenty to talk about.
We'll do it again sometime. I'd be delighted.
Yeah, Dean Smolla, I really appreciate you coming on the show, and I urge people to check out your book.
Thank you.
That was Rodney Smolla. He is Dean and Professor of Law at the Delaware Law School of Widener University and the author of the excellent new book, Confessions of a Free Speech Lawyer, Charlottesville and the Politics of Hate. The book is now available and can be found wherever fine books are sold. This podcast is hosted, produced, and recorded by me, Nico Perino, and edited by Aaron Reese. You can learn more about So to Speak by following us on Twitter at twitter.com/freespeechtalk or liking us on Facebook at facebook.com/so-to-speak-podcast. You can also email us feedback at sotospeak@thefire.org. If you enjoyed this episode, please consider leaving us a review wherever you get your podcasts, Apple Podcasts, Google Play, Stitcher. Reviews help us attract new listeners to the show. And until next time, thanks again for listening.